Well, hello and welcome to our webinar, What do in-house counsel expect from external firms during the arbitral process? We have a fantastic panel lined up today, probably one of the strongest collections of in-house disputes talent ever assembled on a single virtual stage. So I'm sure I'm not alone in looking forward to this discussion. And we are delighted to be co-hosting this event with DLA Piper, and in particular to be joined by the firm's two global co-chairs of international arbitration, Kate Brown-de Veja and Michael Ostrov. I'll give them a quick introduction now. So starting with Kate, among her many accolades, Kate is an Australian national based in Mexico. I'm not sure that's quite an accolade, but it's worth noting. She's an Australian national based in Mexico City, and has been recently appointed as a member of the LCIA court. Although she's done far more than that, I recommend checking out Kate's biography because it's very deep indeed. And keeping with the international theme, we have Michael, who is an American by birth, but who is currently based in Paris. He was recently appointed as a vice president to the ICC court, so we could not be in better hands for this webinar. And on that note, I will hand over to Kate and Michael, please.
Thank you very much, James, and a big thank you to Legal 500 for organizing this with us. We greatly appreciate the opportunity, and in particular for helping select such an interesting topic. This topic is really something that we hope is of interest both to external counsel. It better be of interest to external counsel and to in-house counsel, because it's really about that special sauce. What makes the relationship work when you're facing a difficult situation like a major dispute and you're gearing up for an arbitration, and the getting insight about what in-house counsel expect from outside counsel. And we could not be more delighted to have such a powerful panel. And please allow me and Kate to do a brief introduction of people. I'm going a little bit on the order in my screen. We have Helen Graham from Dutco. Helen is the general counsel of Dutco, which is based in Dubai and includes leading contractors in the region. They also handle manufacturing, freight, logistics, hospitality. And like most of our panelists, not just an in-house experience. Helen is trained and qualified as a barrister and solicitor in New Zealand, also qualified as an English solicitor and a solicitor advocate of the High Court of England and Wales, plus trained as a mediator. So Helen can bring us a wide array of perspectives. And I can't help but noting that her company, of course, will be familiar to absolutely everyone who studies international arbitration. When I'm teaching my class over at Paris 2, the Dutco case is there to remind everyone about the importance of the equality of parties in the role of nominating arbitrators, and led to modifications of rules at every institution around the world. We also have next on my screen, Eric Christian, from RED, which is a company that's part of Energy Impact, specialist building services and ICT engineers, really leading the drive towards zero carbon for over a decade, really therefore touching on many hot button issues of the day. Eric has a lot of experience in construction, complex project development, project finance, and dispute settlement. So although in some ways a project lawyer from the original perspective, he has a master's in construction law and dispute settlement, and really can give a tremendous experience from the business side. So we look forward to his comments. And I also then have next on my screen, Sébastien Ribac from Bouygues Bâtiment International here up the street from me in Paris. Sébastien is also working, therefore, in one of the top construction companies of the world, also specializing in dispute resolution. And Sébastien brings really tremendous specialized dispute experience, having worked in one of the top boutique firms based in Paris and Egypt, working here in Paris with that firm, and then also working in 2 major international law firms before moving in-house. I think it's 3 years ago. Is that right, Sebastian? And therefore now shifting over from the outside counsel to the inside counsel side. And let me pass the baton over to Kate for the remaining introductions.
Thanks very much, Michael. From Europe to Latin America, we are joined by Moises Hernandez from TC Energy. Moises is Senior Legal Counsel and Compliance Officer for Mexico and Latin America. And in this role, he advises on TC's supply chain, business development, and gas marketing areas, and serves as part of the legal team responsible for arbitration matters in Latin America. TransCanada was among the companies that successfully bid for contracts in Mexico's midstream sector following the 2013 energy reforms, and has built several natural gas pipelines in Mexico, including the country's first undersea duct, which was a major undertaking. In addition to his work at TC Energy, Moises is also a member of the Barra Mexicana Colegio de Abogados, that's the Mexican Bar Association at the Energy Commission. And finally, Christophe Laubier from GE Renewable Energy. Christophe is Senior Litigation Counsel for GE's wind, solar, and hydro arm, where he manages all things disputes globally, from pre-dispute strategy to full-blown arbitration. Based in Paris, prior to joining GE Renewables, Christophe was a senior associate at Jones Day, living and breathing international arbitration from the outside counsel perspective. And so he's certainly another example of having seen both sides of the coin. And we're really looking forward to hearing from Christophe's perspective as well. So shall we start things off, Michael?
Well, I did just want to apologize to those who tuned in specifically to hear Johanna Rutberg's insights. Johanna unfortunately had a last-minute scheduling conflict and cannot join us today, and she sends her apologies, but we are very eager to proceed with the star power that we have on the screen right now. Just a couple of points. So the goal today will be to cover, basically to engage in a conversation and get points on something which is not discussed perhaps as much as it should be. Outside counsel and in-house counsel are working together all the time, but the number of times we actually take a step back and say, okay, well, what is the advice from in-house counsel to outside counsel about what they're really looking for, and avoiding faux pas and improving the relationship is not something that happens as routinely as one might expect in this business. So, obviously we know that our in-house counsel expect excellence and expect reactivity from their outside counsel. But what we'd like to do for the next hour is review the issues, including the changing roles that we see as in-house counsel have more and more specialization, changing roles perhaps as a result of changing communications in a post-COVID era, and looking at some different phases of times of the engagement. So we will look a bit at what's expected in terms of early resolution, the role that outside counsel are expected to take at that phase, try to look at some of the questions about how to build trust, what in-house counsel expect in terms of outside counsel's behavior in that respect, including through being aware of sensitivities to budget. And then move on to sharing some thoughts about the role and the sharing of roles during actual arbitration proceedings. There is a Q&A function in the webinar, and I believe James will be moderating that. So please, as we're going along, if you've got any questions, please post them, don't hesitate, and James will pass those through at the appropriate time. And then finally, a disclaimer, this is being recorded. So if you do post anything into the chat, please be aware that it could be mentioned with the recording. And if you don't want that, please don't post anything into the chat, into the Q&A. So with that intro, unless I've forgotten something, let me hand it over to you again, Kate.
Thanks again, Michael. So we're going to kick off, as Michael said, going through the various phases of dispute and how outside counsel can be most useful to in-house counsel at those various stages. And we want to begin with early resolution. So when the dispute is still in its early stages, there's not been a notice of arbitration filed as yet, and where we're considering perhaps alternative dispute resolution mechanisms, including mediation. And we're keen to know, when is the right time to get external counsel involved, and what do you need from external counsel at that point in time? And Helen, could I come to you first? When do you involve outside counsel typically, and what do you need from them?
Sure. I think there are a few situations that might arise where in the early stages external counsel have a great role to play. Quite often there can be a reactive impulse by the business when their attempts at a commercial negotiation are thwarted, and there is a knee-jerk reaction to perhaps want to initiate an arbitration, and involving external counsel can therefore at that time be for the purpose of slowing things down, getting the business to take a more measured view, step back and get a kind of a reality check on their prospects. Another scenario I could imagine is where in-house counsel sees a counterpart in a contract perhaps adopting what looks like a claim building strategy, and that may be a time to get external counsel involved, likewise to deploy a strategy to slow them down, to enable your business to start catching up and preparing to defend itself. Another time maybe to be having talks with external counsel is where the value of the likely recovery you might have in a dispute could be eroded by the costs of arbitration or a traditional arbitration and legal processes. And it's sometimes useful to brainstorm with external counsel alternate strategies to get recovery and alternate cost structures to achieve objectives.
And when you say, okay, it may be time for us to get a little bit of a reality check on prospects and for the business to understand how this might look like, not just from their perspective, having lived and breathed the project now for a long time, but how a neutral decision maker may see it. When you're getting that kind of case evaluation, assuming you're looking for a fairly honest perspective and not one that overinflates the prospect.
Very much so, very much so. Quite often there will be a constraint on the time and resources of in-house counsel to have made that evaluation themselves. So if there is a very lengthy, complex contract that's non-standard, very detailed factual issues that have not really been prepared to an evidential standard, together with technical analysis of it, then very often it's about raising the awareness of the business that the evidential standard required to get ready for arbitration is much higher than what they are used to doing for commercial negotiations. So we want a fairly very clear exposition of what's required to get the business from its state of preparation now to being ready for arbitration before it thinks it's ready to start and push a button and initiate an arbitration.
And I imagine that part of that evaluation process is also giving some fairly serious consideration to counterclaims, because it's sometimes, as you said, quite a knee-jerk reaction to want to start the arbitration, but then some serious consideration has to be given to what you might receive in terms of counterclaims if you proceed down that path. Absolutely,
absolutely. And I mean, I would observe actually from the opposite point of view that we have defended arbitrations brought by others in which the claimant came out with nothing, and we as the respondent actually through our counterclaim had the largest outcome and then are the winner of the legal cost battle and interest. So I think it's very important for a claimant to think about whether they aren't actually rattling the cage of someone who doesn't actually have a big counterclaim and is ready to deploy it.
I want to go perhaps to you, Sébastien, and understand from your perspective, apart from giving you sort of a reasonable assessment of the prospects of success, and obviously perhaps a realistic budget for the arbitration as well, in the event that the matter doesn't go away, so that you can present to the business what this will look like for them in terms of a cost if it has to go forward. What other aspects can your external counsel bring to the table to help you make decisions at that early assessment stage?
Thank you, Kate. First, what we need to understand is that my entity works in several countries outside of Europe. So basically where we don't have any knowledge of the domestic law. So in order to shape our strategy, we would need first to have a better understanding of the legal system there. So that's the first thing that we would expect from our counsel, is to explain basically where we are and what we can do and what we can't. They will also help us to factor some very important aspect that will also help us to shape our strategy, like question whether a time bar is valid under this jurisdiction, because if it is, we would need, for example, a way to circumvent this or to have it applied depending on our position. And if it's not, we can't rely on it. We would need to find another way to get our claim for extension of time or for a related cost to find a way to have it and to get the money we want, basically. So that's the first thing. The other aspect where I see it very important to have outside counsel helping us is that in some cases, just the fact to receive a letter from an external counsel with the firm letterhead can be a huge help, because the company we are discussing with, and where sometimes we can't find any agreement, and it's very difficult to discuss. They realize that we are serious about our claims, about what we are asking, and this can bring everybody to the table, because management will be made aware of this type of letters, which will improve our negotiating position.
I think it's absolutely right that once you see the person on the other side of the table take that step to involve external counsel and have them be present and have their letterhead there, it definitely changes the dynamic. Moises, could I come to you? I understand, TC Energy has some particular experiences with arbitration and pre-arbitral procedures, particularly in Latin America, and some interesting experiences with clauses that provide for other ADR procedures pre-arbitration. I wonder if I could talk to you a little bit about how outside counsel can help you through those pre-arbitration stages of a escalating arbitration clause.
Sure, Kate. First of all, and before entering in substantive matters, I would like to mention that all my comments and thoughts during the webinar I based on my own experience and do not reflect TC Energy position on this regard. You were, touching a very sensitive matters and points for us regarding arbitration in Mexico and in Latin America. In my experience, we need to get involved external counsels in two main steps. One, as you mentioned, is the pre-arbitral stage, where we really need to get assistance of our external counsels regarding the clause per se, the dispute resolution clause, because we have found during the years that, for instance, all these IDR procedures such as mediation and expert determinations are rarely useful and successful. So we found those process a little bit, I wouldn't say a waste of time, but unsuccessful for our purposes. Therefore, we do not spend too much money and time on this process. but we do use a lot of external counsels regarding the drafting on the class, and to be consistent, because some of the times we settle the seat of arbitration somewhere else different to the governing law of the contract, and the parties are also different, are different from the jurisdiction or the governing law, or also the seat of arbitration, and then you come with a lot of conflicts, and when you want to collect award in some different jurisdiction, it takes a lot of time on that. So on my experience, when we came into the conflict, and it's and there's and the dispute is uncurable, we better decide to go direct to the arbitration process and to not involve our external counsels for these matters. And also another very important matter to have in consideration and to have in mind is the cost efficiency. When you do not settle properly in the arbitration clause, for instance, the language of the notifications, when you are dealing with foreign jurisdictions, you need to spend a lot of money on official translation, and then it becomes also hard to determine the arbitrators, because they need to be fluent English and Spanish, and to know, like both legislations, Mexico, US, or Canada. So then the range and the possibilities to appoint an arbitrators becomes very difficult to appoint, and also it increases your expenses. So my suggestion is to include and to put a lot of attention on the pre-arbitral stage, but more focus on the drafting of the clause.
Yeah, I think that's very, very keen observations, and I think we've all had experiences of looking at the clause and finding that it's just not clear when you can actually commence the arbitration, and whether you fulfilled all of the relevant pre-steps, and how you can prove that you've fulfilled all the relevant pre-steps to commencing arbitration. And that can be a source of frustration at the beginning of things. And as you say, depending on the seat and the applicable law and where the parties are from, there can be different interpretations. Christoph, can I open this up to you as well and see what, in your view, when do you seek to involve outside counsel at this pre-arbitration stage? And what do you like to see from them? Is it anything different from what we've heard?
No, it's mostly that. I will say that, sometimes we involve outside counsel, sometimes we involve an expert because, we know our contracts and more often than not, it's a technical dispute more than a legal one. So we might involve experts. If we can't settle, then we involve outside counsel. The most important thing, the cardinal sin of an outside counsel is to tell you what you want to hear. That's useless to me, especially that our team, we're all former, we come from firms, from private practice. 7 or 8 times out of 10, I already know what the assessment is going to say. I already know, but I need outside counsel's stamp of approval because they're going to go through a lot more documents than we do because we just don't have the bandwidth. They will know, the latest case law, the latest articles, etc. So they have a better knowledge, right, of the applicable law. And so we do need their opinion there and, their experience, expertise. And then it's a discussion, right? But the worst thing you can do is give me like a rose tinted glass view of things because that's not what I need. I need to manage expectations internally. And if the business knows, if you tell a business you have a 70% chance of winning, they hear they're going to win. I usually tell my business, you have a 30% chance of losing. And it frames a lot better, right, what's going on. So, involving outside counsel, no 2 cases are the same. But certainly you don't involve them like the day before you want to file, right? It's much before. Trying to involve them as early as you can, provided it makes sense from a budget standpoint, that you should start incurring costs on that. The most we can do internally, we try, but yes, and it's true that involving outside counsel, having a letter from a firm definitely focuses everybody's attention. Because basically what you're saying is I'm starting to pay somebody to fight this. You have to do the same. Ultimately, you have to be two to tango. If opposing counsel, tells the other side what they want to hear, nothing's really going to happen until an award is rendered.
We always thought that it was people were frightened by our letterhead and our reputation, but it's actually just that they realize that you're starting to spend money.
Well, yeah, and that they have to do the same. But so having your name on it helps.
I think we're hearing the message loud and clear, which is an honest assessment, no rose-colored vision of things, and actually really considering how you frame the prospects of the matter for the business, a realistic budget as to what it's going to cost if we can't find a reasonable business solution. An assessment, if it's a technical matter, then that may actually provide the right solution. But if you are looking at counsel, then helping you get through those initial sort of issues with any potential clause is important, and the impact of letting your counterparty know that you've involved an external firm can be extremely helpful. When we think about some large construction projects, so switching a little bit for the fact that it's just you on one side of the table and maybe a contractor or subcontractor on the other side of the table, when you're dealing with some of these larger construction projects where you often have joint ventures and consortia and the additional complications that means in terms of retaining outside counsel together with your partners in that business. What additional complications does that bring? And what additional skills does that mean that you look for in that external counsel to help manage the various interests that are then at play? Eric, we haven't heard from you yet. Could I come to you first on this and give us a little bit of your experience as to how this dynamic changes and what additional things you're looking for?
Of course, yeah, thank you. The larger projects, indeed, you have two major players. You can have 3-4 players in the joint venture. So the first hurdle is always getting everybody to agree on, yes, we have to start an arbitration. Of course, sometimes a decision is not taken by you and is taken by the other side. So you have no choice. But then, of course, the clash of the panels, as I call it, starts. So everybody goes to their own panel, has personal and good experiences with their own panel and their own lawyers. And so then the keys trying to come, first of all, compromise which law firm to appoint. And this is where the external counsel has a role to play, because they will have to do a beauty parade to ultimately convince the skeptical joint venture partners that they're just as good as their panel. And even more key, that they have a neutrality towards everybody in the joint venture, so that they're not in red NG impact friendly firm, but they're saying, no, we're going to defend each and every party in this joint venture as equally and as transparent as any other pre-existing client. Where the tensions can come up is, of course, during some arbitrations, and it becomes clear, okay, we may be on the losing side, payment will flow, and suddenly, between the joint venture partners, there may be already certain frictions and saying, well, you were the partner responsible for the construction, you were the partner responsible to supervise the design. So at that stage, they are, especially if the joint venture partner was that now maybe have bear responsibility and is linked to the law firm appointment, it becomes a very thin line for them to walk, that they keep their neutrality at the end of the day, even in those circumstances.
And that each of the joint venture partners feels secure, and as you say, feels that they're being attended to in a way that is both neutral and representing the best interests of the joint venture as a whole, as distinct from just a single partner.
They can't draw the card of one partner. They cannot do that.
Yeah.
And when the time arises, they may advise, everybody appoints their own as well in respect of possible future disputes within the joint venture, that they appoint their own lawyer to supervise whatever the external counsel is also doing.
Yeah, it's a tricky line to tread, that's for sure. Helen, you've had some experience of this as well. Even when Dutco is the leader of a joint venture, the choice is not always up to you.
True. I mean, I think it's very common for a joint venture agreement to provide that arbitration proceedings are something that require the unanimity of all partners, and rightly so, because arbitration is costly, a great use of or diversion of management time, and there are opportunity costs of being in arbitration and reputational issues. So I think rightly so. The lesson I have learned, actually, I think, is that to ensure that your joint venture clause doesn't provide that defending an arbitration requires the unanimity of the partners, because we've come unstuck there. But also I would distinguish the conduct of the arbitration, because my experience is that when you're in a situation where someone wants to arbitrate against you, that there is probably things going wrong and there will be disputes between the partners as well. So it is not going to be easy to marshal them. And I think the easiest thing to do actually is to have an appointment of a lawyer for the joint venture at a very early stage before things get too contentious. And that I would say that our approach has always been that the firms beauty paraded are ones who haven't really done any significant work for any of the partners. So there is the neutrality that Eric was talking about. I think that's really important. Something that we've observed is, because I think of the various personalities and each joint venture partner maybe having their own agenda, it's very difficult for external counsel to manage joint venture partners directly. And having struggled with that, we found a more successful approach was that the leader in the conduct of, it was actually a pre-arbitration stage, that the leader actually interfaced with external counsel and kept them away from the joint venture partner representatives, and was a buffer, and was therefore kind of almost like selectively feeding information to the board, and being the one who was primarily responsible for instructing external counsel. And I think that made an external counsel a lot more comfortable, because we had experience of a conflict of interest where one of the joint venture partners would not agree with the strategy for defending a piece of litigation, and ended up instructing separate counsel with a different strategy, which was just a disaster. You can imagine the counterparty had a field day. So I think it's very hard for external counsel to be directly involved in that stage, and you need an interface from the leader, and that may also include in-house counsel, though I have to say that I prefer not to be the one advising the JV, because I want to be the person advising my individual company as a partner in the JV, not the JV itself.
Yeah, it puts you as in-house counsel in a tough position as well, if you have to again manage being the advisor to the JV as well as representing your company's interests.
Well,
I think that's a really interesting solution in terms of having, the obviously unanimous approval is necessary in order to commence an arbitration, but then to have in place a system where it is the leader who actually conducts the day-to-day interaction with that external counsel and who decides on the strategy for the JV and advising the counsel. Is that role of the leader in that something that's typically included in the JV agreement, or is that something that has to be negotiated when the dispute looks like it's coming down the pipeline?
I think that is something that needs to be negotiated unless you've got it up front in your JV agreement, which I would do. But a point I'd like to really make there is that does leave the leader very exposed. And I think that's where external counsel can really help by creating a very clear written record of their advice and recommendations around strategy and the process by which other options and opinions are considered about how the conduct of the arbitration unfolds, so that the leader there has the protection, so to speak, that the decisions have been made on a reasonable basis, because usually their responsibility is not absolute, it's just to have conducted themselves in a way that's demonstrably reasonable.
Yeah, that's really interesting, and I think that's really good advice for outside counsel. Perhaps if we move then from the situation where we're in this sticky scenario of having to retain outside counsel and then decide on the legal strategy going forwards, where we're only one member of a joint venture. If we move from that scenario then back to perhaps a simpler scenario, but where there's still a chance to reach amicable settlement, and we still haven't filed proceedings, but where we actually think that external counsel can still bring a lot of value to perhaps getting us to that amicable settlement. Sebastian, I think you have a good example of where the involvement of external counsel did help you out at that early stage.
Yes, definitely. And after this experience, we decided to offer now, when we have a claim to the other party, to agree on mediation, or to include mediation clause now in all our contracts, because on 2 or 3 occasions when we thought that we were heading directly to arbitration, we were positively surprised of the outcome of mediation. I have in mind one occasion where basically one of the managers on the other side was very opinionated and emotional, and it was very, very difficult to try to explain that we had some entitlements, and we couldn't really have a rational discussion with him, and we decided to offer mediation because it's let's say for 10 or 15,000 euros per party, you can try to reach an agreement, which is very little compared to arbitration when you start. And also, as we said earlier, it sent a message that now we are escalating the claim and the lawyers are on board. So both parties brought their lawyers, and when we thought that it was in London, it was supposed to last 2 days, but we were sure that we would stay only half a day and taking the Eurostar back to Paris. And surprisingly, we stayed the 2 days, and our lawyers were very helpful because they were much less emotional and rational. And when basically the consequences of a non-agreement and all the costs that would be spent in arbitration and all the risk for both parties were clearly spelled out, both parties decided to sit on the table and try to reach an agreement. And when we get rid of the emotional content, we figured out that we could find an agreement, and our lawyers were very helpful because we had some discussion directly with the mediator, but sometimes it was also just the lawyers with the mediators to try to have a conversation with people with less interest in the disputes, so to speak. So reach an agreement, and the fact that the lawyers were present during all the mediation was very, very helpful because they could reduce the agreement quickly to writing and minimize all the discussion afterwards, because when you wait 1 or 2 or 3 weeks, you realize that, okay, we didn't discuss that, and we can spend months or resume the dispute because we cannot agree on things that could have been agreed if we had 2 people or 3 people or a team of people working directly on the settlement agreements. And also because since it was the law applicable to the contract was not French law, these lawyers were qualified in the jurisdiction of the applicable law, the governing law, and they could answer some questions. For example, some of the things that we wanted to add, explain that it was already part of the law and we don't need to discuss that because it's part of the domestic law applicable to the contract. And after this, and this happened on 2 other occasions. So now we are very happy to bring lawyers with the right set of skills to mediation, because the cost is very low compared to what you can get from a good mediation.
I've heard it said that the only people who are against mediation using a neutral and a formal process are the people who've never tried it.
Yes.
So I think your anecdote is very telling, and I think it's probably an apt moment to mention that with the Singapore Convention now in place, there is this option for a mediated settlement that uses a neutral and a formal procedure, can then result in an enforceable instrument, which has always enforceable overseas, which has always been one of the things that people have used to say that mediation isn't as effective. So I think that's a really helpful anecdote. And perhaps finally on this, Moises, another ingredient at this early stage can be when your counterparty is a state or a state-owned entity. And I'd be keen to hear from you what additional elements that brings into any early settlement prospect.
Yeah, that's very important and interesting, actually, because as you know, in the oil and gas industry, there are always very long-term contracts, right, or commercial agreements, probably for 20 to 30 years long. So here, what you need, or at least what I always have in mind, is that from now to 20 years, circumstances can change drastically, right? So it's important to have very flexible clauses on the dispute resolution that allows the party to negotiate during the life of this commercial relation. What is interesting is that it's important always to have these mediations. For instance, I guess that it could assist and work on those kind of agreements. However, I guess that it's super important to have something very kind of settled meetings in between high executive management level, because there the talk, the chat, the discussion could be more sensible to the parties when it becomes to the leadership of the company and the state company. And on the contrary to Sebastian's point, probably that could relax a little bit the environment and these talkings if the lawyers are not really the ones that are leading or holding the conversations. But when it comes to private parties, we are taking out from our classes these procedures, because at the end we consider that the parties could agree on a state and to agree to have either the expert opinion and the mediator. At the end, what I have found during these last years is that when you point an expert, at the end, it has some leverage on your side, and it's the same with the expert on the other side, and you need to appoint a third one. So this delays a lot the process and the resolution of the dispute, and also the majority of the time, the expert also relies on technical aspects. And then if the problem has some ingredient different from just the technical aspects, then it could be questionable the appointment of the expert. And when it comes to the mediator, it's challenging to appoint that mediator that do not has conflict with the parties, and here I came back to the contracts where the state take part, because the most of the time are the same kind of mediators for these matters. So it becomes a little bit difficult to agree on the expert or the mediator.
Yeah, those are clearly important. And in smaller markets or where there's less experience, you do get the repeat players there that sometimes we also see in arbitration. Michael, shall we move on to topic 2?
Sure, if everyone's ready. Although topic 1, I think, was fascinating enough that we could also continue for another hour on it. We had some interesting questions in the Q&A that we'll come to towards the end, and some of them actually cover on the topic that we're moving on to now. So let's move on to that, which is the issue about in terms of the relationship between in-house counsel and outside counsel, and developing the sense of trust and the confidence in the relationship. One recurring issue that we've certainly been seeing on the outside counsel side is that our clients are under sort of increasing budget pressure, and the in-house counsel function is looked at as a cost center. So the first question that we have for our panelists is about case budgets, and what your experience is in terms of negotiating case budgets, and then what sometimes feels inevitable, the renegotiation of case budgets in long, complex disputes. And one of the questions which we can cover and fold in from the Q&A was, do you see sort of fee caps by, do you impose fee caps by phase as opposed to an overall fee cap? Do you have favorite ways of breaking that down? So maybe Eric, if I could start with you, what is your approach towards fee caps, assumptions, and other budget tools?
So we always go to fee caps. That's kind of a requirement. And it's not an overall fee cap, but it's generally a fee cap per stage. There's some rolling over, rolling back, indeed, between the stages. So, but as long as there's a fee cap. Of course, what I find very interesting is the assumptions, because although a lot of external law firms come with a fee cap, once you start analyzing the assumptions, a lot of these assumptions just break open the fee cap, and it's just not worth the paper it's written on. Why am I so skeptical? You see assumptions of, okay, we're not going to revise more than 10,000 emails. As you know, larger projects, they span 1 year, 2 years. If you consider the flow of 10,000, I think you probably have already reached that for 1 week. It's so it just doesn't go very far. A second, of course, he says, as long as the arbitration is not more complicated than what we intended. And yes, I am, of course, an internal counsel. My background is slightly more commercial. So you think, okay, what do you mean with that? And if you look at the law firm's proposals, they say, look, the law firm has so much experience over so many years, and these are the key people we're putting, all with so much experience. And you say, well, you should be able to tell me, you have so much experience, nothing should be more complicated than we already have. Ours will be easy. So it's especially because some of the law firms, as you said, they have been involved in the pre-arbitration discussions. So they have had a certain amount of analysis of the facts. So they should be much more harder in respect of a fee cap. Of course, we cannot be unreasonable because there could be certainly things, events, side disputes popping up that were never foreseen in the first place, that were really possibly a strategy from the other side that was not foreseen. So at the end of the day, you have a continued relationship with your external counsel. So you have to be reasonable. But as you said, it's a mutual flow. And I repeat Christoph's earlier, you have two to tango. It's not always a one-man show. Because at the end of the day, if an external counsel, if you cut saying, oh, we're not paying this and this and this, their motivation to support you in your arbitration may also a little bit lower over a longer period. But it's certainly the assumptions, we certainly question the assumptions and the relevance of these assumptions.
Thanks. So Christoph, picking up on that and on the two to tango, what do you say to us when we say, okay, well, can we just put in no assumptions and just say, here's our cap, and then just hope for the best down the road when there's so much unknown early in the stage? How do we get comfort and certainty in this uncertain world?
If you want to give me a cap with no assumptions, I'll take it. But usually you have more assumptions than I like. But you'll have the classic, 3 witnesses, 2 experts, 5 days of hearings, 2,000 documents to be exchanged at doc production, that kind of thing, and it makes sense. But yeah, the rule of the game is predictability and certainty. We need caps or flat fees, anything that the business can start budgeting in advance. And we need monthly billing. I can't get a huge invoice after starting working. The business is going to go crazy, and it's all about predictability, right? If the same amount invoiced monthly works, one huge invoice does not work. Most importantly, all of this is about trust. Ultimately, there's trust from the client that the firm will bill honestly, right? And there's nothing worse than having, looking at invoices and seeing that 15 minutes here for just a call because I called a lawyer and he's billing me that few minutes that we talked, or just like an email. I had a firm send me an email saying, just wanted to catch up, see if there's anything new on this case, bill me that email. I had a firm write me a memo that was terrible. I spent 2 hours explaining to them why it was incorrect. They billed me those 2 hours. And then the next call, when I fired them, they billed me that call as well. And it's just insane. So there's trust there. And there's also needs to be trust on the other end, right? Where, yes, we agree on assumptions and we'll be reasonable as to if those assumptions have changed, and it does happen sometimes that a case takes on a whole new aspect that nobody foresaw, and we're reasonable. We've been there. We know that it's important. So we review the budgets. And there needs to be trust there. Where I do draw the line is the issue of bait and switch, where you'll have a firm come in with a really competitive offer, and then so you hire them on the assumption that they're going to live by that offer, and then midway through they say, sorry, I'm already done with that budget, it's going to be twice as much. Nothing has changed, right? But then we tell them, well, actually now you're at a budget where the other firms were, but they were honest enough to tell me up front this is how much it's going to cost. So that's where I push back and I do not review budgets. But then ultimately, if the firm stops working, those ultimately will never work again for us. But it's a very difficult situation. So there needs to be trust on both ends, and we only work with firms on repeat, right? Because once you've earned our trust, then we keep coming back. That's just the rules of the game.
Thanks. That's thinking about that relationship of trust and the question of whether the upfront estimate is a fair one or not. One of the questions that just popped up in I think it's in the chat because I couldn't find it again in the Q&A. Was what about success fee arrangements? Do you, and maybe I can turn the floor over to Sebastian for this, do you like to see success fee proposals, or does that create less certainty about what your budget actually is going to be?
I'm going to answer to your question, but before I totally agree with Eric and Christophe. I think we had exactly the same experience, and also I had some interesting experience like Christophe, where basically I've been billed 14 minutes to receive a message from our lawyers just to wish me a Happy New Year, and they bill me the 14 minutes for a Happy New Year message that they send me, or an international law firm, I will not say the name here, where we asked a question about an African country, a question about law in an African country. And basically we received a 20 pages memo where just one page was relevant, and we had to explain that our question was very simple. So why 20 pages where one is relevant, and they charge us a huge amount of money. And we had 6 lawyers from their Paris and 6 lawyers from their London office to have such a bad memo. So we had to say, we can't pay that because basically you didn't really reply. You replied to half of the questions. So it's really a matter of trust and not to overcharge, the company, because we need certainty, and we are checking basically, the invoice every time. And to reply to your question, Michael, as I explained, we shape in part our strategy based on the assessment made by the law firm. And when the law firm says you have a huge, it's highly possible, or we really think that you are going to win, this arbitration. And then I ask, okay, so the amount of work, so exactly the same issue as Eric and Christophe, but just to keep them motivated, I will say, okay, let's negotiate to have a cap or a lump sum plus success fee. And I'm always surprised when the firm says, no, we don't accept, we want to bill you by the hour, or we just want to have a cap, and let's get the cap higher or the lump sum higher. We don't really want to have success fees. And it's just, an incongruency, because basically you are saying you are going to win, or we are not sure you are going to win. And the amount at stake. We give you all the documents that are asked to get a proper evaluation of the case. And the firm doesn't want to take risk. And the way now we see law firms is more business partners. It's not just, services that we are paying for. They are business partners, because if we are satisfied, that means that we are going to work with them on other cases. It's just, it's not a one shot. And when the firm basically refuses that, I don't see it as a business partner, but just somebody who is going to come, and it will be more a mercenary. It will come, one shot, one kill, and then move to the next company. And that's not the way now in-house counsel, or at least here at Bouygues, we picture our legal counsel, because we have rosters of few law firms that we want to and we like to work with, And it's also based on the relationship that we are building. And the fact to refuse a success fee on top of a cap, when you have the motivation and where basically you made the assessment that it's highly probable or there's a high possibility that we are going to win, it's hard to understand on my side.
Thanks. That's an incredibly interesting perspective, because I think sometimes on the outside counsel side, firms are nervous about suggesting success fees, precisely because they're concerned that companies will think, oh, in terms of the upside at the end of the day, we're going to be sharing more of it. It's going to make it more expensive. If you're confident, let's just know what our budget is. But this idea that it's a partnership and there's risk sharing is an important perspective. I'm very conscious on time. We were hoping to save 20 minutes for Q&A at the end, and we do have a great number of questions. If we could just perhaps move on to the third category of points that we wanted to cover, and let me pass the floor back over to Kate, and let's just spend, I think, 5 or 10 minutes on those relationship points and then move over to the Q&A.
Thanks very much, Michael. And we've talked about this third topic as being sort of the working relationship during the proceeding and how to make sure we maintain the relationship. But as I went through the planning for this session, I thought we could almost relabel this section pet peeves. Like, what are the things that outside counsel do that really irritate you and you wish they wouldn't do? And what advice would you give them in that regard? So I want to go straight to you, Eric. What's one of your pet peeves?
Outside counsel that are indeed you're dealing for most of the time with the arbitration, the litigation department, not understanding the commercial or in fact the legal underlying dispute. So when they come back to you and you see the draft and you think, oh, they never understood what the legal question was. They look at the arbitration and how to start and whatever, but not necessarily, I'm the commercial guy. I deal with certain legal aspects all day in and out. And so when they haven't understood what all the nuances are of the legal underlying dispute topic, that is always a bit scary.
And you know your contracts and commercial arrangements better than anyone. So there should have been earlier conversation with you. Is that what you'd like to see?
Correct. And at the end of the day, the external counsel have to be a specialist wearing two hats, both in respect of the underlying law at dispute, and the second hat is the litigation and the process laws. So it's they have to be the geniuses, the highly specialist people. But it is sometimes, it's a little bit scary when you see, oh, they missed the underlying point, because of course then you start questioning the valuation or evaluation of the case that they've done at an earlier stage.
Yes, not particularly helpful. Sébastien, a pet peeve from you?
Yes, apart from losing a case when you told your management that basically it was unlikely to happen, I think that to have a Pyrrhic victory is one of the worst things that can happen. How to explain to the managers and the leaders in the group that we won an award, we have a beautiful paper, but we can't do anything with it because the losing party is insolvent, or it's somebody, or it's a state entity, and we cannot claim anything because we are in some countries where we know that the award won't be applied. And basically, we are working with a law firm that is saying or telling us, you're going to win, but without telling us, but you never get your money back. And that's something that is very irritating.
So early assessment of enforcement prospects.
Exactly, yes.
Helen, you like to be quite involved in the management of a case, at least when the amount that's at stake merits it. We see a push from institutions, including the ICC recently, to make sure that in-house counsel are involved in the interactions with the institution, that they're copied on correspondence. I'm keen to hear from you. What level of involvement are you looking for? And I guess what's a pet peeve in terms of arbitration counsel sometimes not giving you the role that you need?
Yeah, I'm very happy to be copied in on the correspondence with the tribunal, because I would expect to always have had a report anyway about any correspondence with the tribunal. It's usually a pivotal procedural point, so that I might as well see it. So happy with that. Like to be highly involved in the team. Can quite often push myself forward to being almost the leader of the arbitration team and case managing it, particularly where you have to be the coordinator between the business, organising access to evidence and access to witnesses to prepare statements and so on. So I'd like to be involved. Something that actually I think is quite interesting is getting the opportunity to be sitting in on a case management conference. Perhaps because as the client in the room, there's an opportunity to be perhaps a little bit more forward with the tribunal than your external counsel can afford to be professionally. And as in-house counsel, you can very much be the client and indicate your surprise and perhaps disappointment if there is discussion about procedural steps which you think will cause unnecessary costs and delay. And I think it's quite useful to be the client in the room, and you're the client of the arbitrators as well as of the external counsel.
And I think that's interesting because there may have been historically a tendency to have the external lawyers be the ones talking to the tribunal in these conferences and even at the hearing. Whereas I do think there's a tendency towards in-house counsel playing a much more active role and of course speaking up when issues come that are of concern to them, and there needs to be space for that.
Absolutely. I think this is a good development.
Other behaviors which irritate. We're going to come to another couple where we're sort of, this is a bit of a speed section of the talk, but Sebastian, I think you have another one to add to the list.
Yes, the timetable for review. Since I've joined the group WIG, I had some experience where I received memos or I received a statement 2 or 3 days before they had to be submitted to the tribunal. And basically the message that I received from the from our counsel was, okay, you have 1 or 2 days to review, so okay, I can implement all your changes. And I know that since I've worked for 10 years in private practice, that it's the way that things are done, in law firms, but that's not the way things work when you work in a company. You need more time, and you cannot be, put on the spot and just, you had 2 days to do this or you're going to be late. And I think that it's a matter of management of the case, and this should be taken into account that people generally, we work hard, very hard, but you need to give more time. It's the same when you are in a law firm. Basically, if I ask you, okay, you have 2 days to do that when it takes you 6 days, you cannot expect to have the best results. And it's the same when you work with your in-house counsel. We have other important matters, not just one, and we need to have more time. We are also very busy and we need to organize our workload like you would do in private practice.
So I want to make sure we've, Eric, absolutely passing the mic.
Discovering that the same law firm in another country is acting against you in a case, that is one of my big pet hates, because as Sebastian said, it's a matter of trust with the law firm, and that you discover, oh, but they've started acting against you, another case, independently, against an entity that belongs to the same group. And that is something I personally really dislike.
Wow. That's a big one. Now, I'm like Michael, I'm conscious of time, and I know we've got quite a few questions, and some of the questions that have come up in the chat actually mirror some of the other talking points that we had, including arbitrator selection and things like that. So I wondered if we might turn now to some of those questions. And Michael, I think you have pre-selected a couple to kick us off.
I have. So that question that you just pointed out does go directly with this topic, which is one of the participants asked what you as in-house counsel expect from outside counsel, and also expect your own role to be in selection of arbitrators and in selection of experts. And I might note on that a couple of you mentioned retaining experts early, sometimes before you've retained outside counsel. So it'd be very interested to know your thought process about how you manage the two issues together. And open mic for anyone who'd like to speak up. Or it's going to be like my arbitration class and I'm going to call on somebody.
Certainly, I think having external counsel's input on their experiences of arbitrators is extremely valuable, because that you can have a frank off the record conversation about the foibles of certain arbitrators. So I think that's a very valuable input that I look to external counsel to provide. I'm extremely wary of experts, and I see them as a major area for cost overruns, actually, and it's even harder to, while I completely agree with my colleagues' views about cost overruns of budgets with external counsel, it's even worse with experts, because they have their independence card to play, and in some respects just think they have a blank check. So external counsel having a very strong relationship with experts is very important also to keep that under control.
Following on current comments, and Eric, definitely what we are looking for is further expertise, right? For the details, and to have previous experience on process of the same nature, because we are not looking just for an expert on arbitration process, but at least in my case, sorry, with experience on the oil and gas sector, particularly on pipelines, and try to get their experience in some other process of the same nature, but do a step forward or on your counterpart. Something that it's important for us, or has been successful here in TC, is that we hire external counsels that help us in the US and Canada. Therefore, you kind of create a very strong link and commitment in between the parties, because if they start to charge, as Sebastian mentioned, just because of an email that they read, or for a call phone to say hi, and all those things that sometimes happen, they are probably losing a big client with international exposure. So probably we talk about a very single case, it's not that relevant, but when it becomes to the regional and to the whole company, probably they are losing a very important commercial body. So that's also something that we take in consideration. And with that, you are familiar and aware of the way that external counsels works, and you are not expecting any kind of surprise regarding cost, experience, leverage, and at the end, the professional skills that you are looking for.
Picking up then on another question, and by the way, thank you to everyone who's put in questions into the Q&A. We will not be able to get to all of them, and some of them go on to some side topics that are fascinating, and we can try and hold on to them for other webinars. One question picks up on something that several of you raised earlier, and I think also connects to some initiatives, for example, that the ICC is trying to put in place with respect to more implication of in-house counsel in the process. But with respect to speed and efforts to accelerate the arbitral process, Helen, you mentioned liking to be present at some of the procedural conferences. The question's asked, do you discuss with outside counsel techniques that you would like to see put in place in the arbitration to speed up the process, so that you actually strategize with outside counsel before the procedures are agreed? Is that something that you routinely do? Do you look for leadership from outside counsel on that?
Yeah.
Do you drive that?
It's a dialogue with outside counsel, but I would definitely be strategizing with them how to manage the procedural aspects of the arbitration to ensure that it is, delivers the most favorable outcome for us, as well as being most cost effective. And actually, in a jurisdiction where there is overlap between common law and civil law, in terms of the experience or expectations of the parties, there's a real tension there, and that's a real area for strategizing, is how to manage whether there is a more civil law biased approach to the procedural approach or a more common law approach, which side suits you best in the situation.
And Sébastien and Christophe, both of you who have practiced extensively in the arbitration space on the outside counsel side, you must have your own views also practicing in-house about how you want the case to be run, whether you want more discovery, less disclosure, whether you want lots of witness testimony. How much do you dive into those debates with outside counsel and expect to be part of the brain trust running the case?
Want to go first?
Let's go first, Christophe, please.
Okay. It depends on the case. The big ones, yes, I'm always involved on every aspect. I mean, as the partner from the firm would be, right? So I'll make the call as to what the strategy is, what we're looking for in the proceedings. And going back to the issue of, the common law type of arbitration, or the continental Europe type, we push to the continental Europe type. And so actually I'm going to talk about this, but which I said I wouldn't, but maybe we can be standardized, right? In our T's and C's, for instance, we have added a sentence that says, all of your exhibits, all of your witness statements, and all of your expert reports will be filed with your briefs. Because we want to limit this discussion that you'll have at the case management hearing of how this is going to happen. It depends on the C, depends on you have on the other side, on the applicable law, and then you get on to these crazy discussions. And we try and limit that. It's more efficient. I personally prefer that way also of carrying an arbitration. I think it's more efficient, it's easier. And I'm more accustomed to it as well, so I'm biased. But yes, I mean, we're definitely involved at each state of a strategy. We're on the case management hearings. We will talk to the firm about everything. I mean, we'll do mock hearings as well for the big cases. All of that, we're heavily involved at each stage, and at each aspect of the dispute, we will have decided with the firm what to say, how to say it, when to say it. Which goes to just one pet peeve: going to a mock hearing unprepared is unacceptable. But sorry.
On my side, the way we are organized, that I don't really work a lot on the contractual aspect, but mainly or most only on the litigation and arbitration aspects. So we are very involved into the strategy, and we try to set the strategy, because sometimes our lawyers do not have all the information we have regarding why we try to demonstrate, to reach, or to do. So we try to give as much information as needed to get the best outcome, but we are the one making the call at the end of the day. And sometimes we have some, and it's very important also to know very well our cases. I had one occasion where our lawyers were not that prepared before the hearing, and I was the one preparing our witnesses and basically explaining what were the issues, the technical issues, because our lawyers were very good on the procedural aspects, but on construction, the understanding of the construction industry, they were not that good. So if we are not involved, first there is the reporting aspect where our managers are very involved. And that is why, for instance, also we are trying to develop some AI to assist us inside, I mean, in the company, to help us to have a better, to review everything quite quickly and to reduce the cost with our lawyers by providing all the information, because we will be able to find the information important with the AI and not to send thousands and thousands of documents and 90% of them are irrelevant. We really try now to do all this work so that keep the cost low. We also have to our say when it comes to strategy, because basically at the end of the day, we will be the one losing or winning, and not the law firm, unless they accept the success fees. And there are some very also important aspects, like if our lawyers are not well prepared, we are here. And that happened, unfortunately, on 2 occasions where abroad, when I went abroad, and I had basically to spend 2 days with our lawyers because they didn't have a good understanding of what we were claiming, because the technical aspects and the legal aspects were not something that they were used to. So for me, we have to be very involved, and that's why also now when we decide to hire people, it's people with my type of background, litigation or arbitration, and not people who don't understand the industry or the arbitration world.
I think that's really interesting, Sebastian. What you mentioned about the role of AI and the tools you're using internally, I think picks up on some of the other questions in our chat, and also wraps into what you said, Christophe, about mock hearings and trying to get a better grasp on how certain arguments are going to go and sort of potential success of the case based upon new tools that are available. So we're keen to learn from you whether you're using any predictive outcome software or AI in terms of the outcome of the dispute as a whole, or whether it's still at the document review stage. And do you think are you keen on learning more? Are you keen on an increased role of AI in review of the case as a whole and coming up with predictive outcomes?
Just to speak quickly about the predictive outcomes, my view is that you can have a predictive outcome of 90% of winning and 10% of losing. If you lose, you lose. So basically, I'm not really, and there is such a human factors with the arbitrators, with all that all the predictive tools. As I said, there's nothing worse than going to your management and telling them we have a 90% chance winning and we lose, so they won't understand. So I'm not really sure about. I've seen some demonstration and I'm skeptical regarding the document review. That's very helpful. AI is proving, and we are developing in-house our own AI to fit our needs. And just the testing is very promising, because basically it would help us to be more effective. And which means effective, that is to say, and the consequence is that we can save money and spend it on other important things.
I mean, AI is going to happen, right? I'm not sure it's there yet. There's always going to be inherent human bias, even in the AI, because humans are setting up much of the premises used by the AI, right? But as Sebastian said, it's so, there's a human factor to this that's hard to estimate. And you also had cross-examinations. I've won cases just on ways I didn't expect, because the cross-examination went so well that we discovered things, right? And so there's a human aspect to all of this. That for now, I think AI is useful for document review, right? If you're looking for a piece of information, if you can have the AI, if you can ask the question and then they come up with the right documents, that's great, rather than using keywords. But predictive outcome right now, from what I've seen, isn't there yet, so we don't use it.
Can I follow up? Are you seeing it early on in projects? Like, do you put your project through predictive mechanisms in terms to work out where are going to be the potential points of delay, et cetera? Are you using any of those tools?
That I don't know. If the projects use that for a predictive outcome of the projects, I don't know. For the litigation, we don't use it though.
In our case, for instance, we need to handle and to request a lot of permitting, right, for constructions, and then it becomes, hard because now timing is such an important ingredient for many aspects in construction in Mexico, probably because of the changing of the law, also because of the COVID situation, and we are foreseeing that in our contracts, because otherwise everything could came into litigation, arbitration, and actually we are not also willing to start disputes just because of every single thing and aspect, right? So we rather prefer to focus on things that are substantive for the project, for the construction, and at the end of the day, everything that impacts cost of the project. But that is a very important aspect to have in consideration, the standby times, because that can increase the cost of the project, like substantive. But we do prefer to have some clauses there to prevent those aspects, and to internally discuss with the counterpart and to try to find something amicable and probably a knock for knock, because otherwise it becomes a little bit difficult to handle these situations.
Again, we have some terrific questions in the Q&A. I think we have 1.5 minutes left, so I'm going to take the prerogative of having grabbed the microphone to warp one of the questions to ask something about ESG. There's a question in there about ESG disputes, but there's also a question in there about what you're looking for from counsel you don't necessarily know so well. I'm going to combine the two questions and to ask you, and maybe because of your business area, Eric, turn this to you. When outside counsel are pitching to you or presenting their credentials, do you take into account today ESG issues, whether it is carbon neutrality and whether outside counsel can assist you as a supplier in meeting climate change goals, diversity, governance? Are any of those elements relevant to your decision to select counsel, or is it all about, are we going to win this case?
It's a very good question, and yes, we've had the discussion. It's certainly on the table. It hasn't been the carbon neutrality in respect of a selection of a lawyer. We still will look more and more to the skill sets of the lawyers, less the carbon neutrality.
Relevant at all? A slight factor, or it's really not on the table yet?
It's not on the table yet in respect of the lawyer selection. However, in respect of other suppliers, yes, it is on the table. And it will become mandatory and prevalent, certainly for future selection of suppliers. Lawyers seem to, at this time, still exempt from that requirement. So you're off the hook for the time being. What do we look for in new lawyers? I certainly look very much as the relevant experience of the lawyer itself that is proposed. So I don't look at, because the law firm may have experience in a lot of law firms, but if the lawyers you're going to work with has no relevant experience in what you're looking for, then it's to me it's irrelevant. I'm very much looking, who will I be working with, and how much of this person's time do I get? Because sometimes you have a beautiful parade, and then the lawyer, the partner, disappears because he has another project that may be more exciting, or he's going on the next beauty parade. So I'm very much looking, okay, what is the experience of the relevant people in front of me? how much are you getting engaged? And these are the questions I will ask during the beauty parade. Is it just you being here to sell the product, but are you selling yourself instead of?
Then a quick follow-up on that: will you require specific budgeted time from lead lawyers on the project so that you know that they're locked in, that they're going to be giving you that attention, or is that part of the trust that you discussed before?
Part of the trust, but it's certainly the question we will ask. If we suddenly start seeing invoices where indeed the monthly invoice shows 50 hours of the assistance, which is fine, and half an hour of the partner, then we start thinking, okay, what is your role? It's not what we discussed. It's not what you promised.
Okay.
Yeah, and it's we look as well again on the composition of the team. It's just a whole bunch of junior lawyers, where do we fit, junior, mid-level, because indeed the churning of the paperwork will be done at junior level to a large extent. You have to be, I understand that the law firm wants to be cost effective as well. But it's certainly, yeah, we want to see the lawyer involved if they have the experience.
Anyone else on the 2 points? Do you take into account any ESG in your selection process, carbon footprint, diversity of team, etc.? And how much is it individual lawyers?
Diversity for G is very important. I mean, women and minorities are hugely underrepresented as lawyers and as arbitrators. So that is on top of our list for those two, lawyers and arbitrators.
I think that gets us to time, Michael.
Okay. James has turned on his video, which means the hammer is falling.
Well, no, I was wondering whether you had any final thoughts, either Michael or Kate, to round us off. If not, then I can offer my thanks to you and the panel. But I'll open the floor to you, Michael and Kate, to give final thoughts on this.
On my part, for my part, just a huge thank you to our panelists for sharing their time and their thoughts. These are the kinds of insights that, as external counsel, it's exceptionally important for us to hear, and it's very helpful. And I hope that by sharing your thoughts, you're going to get better service from all of the lawyers who are paying attention to you today. So thank you.
Excellent.
I simply echo Michael's words and thank you for your time, both those who joined us from outside of the people on the screen and those of you on the screen. Thank you so much.
Yeah, well, I have nothing to add, save for a huge thank you to Michael and Kate for chairing such a fascinating discussion. Obviously, huge thanks to the panel for giving their time and contributing to a really important and insightful session. And of course, to those of you in the audience who joined, and especially those who submitted such very interesting questions. And very finally, huge thanks from Legal 500. As Michael mentioned at the outset, a video of this will be available shortly on the Legal 500's webinars page. Anyone who wants to review this and relive the exciting debate can do so. But thanks from us. Thank you, guys.
Thank you, everyone. Bye-bye.